Stay tuned for the next edition of Zoom Landlord Tenant Talk Radio. The opening topic, moving in, moving out, a comprehensive guide for landlords. Hello. Hello, everyone. Yes, another edition of Zoom Landlord Tenant Talk Radio coming at you every Saturday at 3 p.m. If you were listening live, the name of the song was God Bless the USA. It was written and performed by Lee Greenwood. It was released in 1984. The song expresses pride in the American values and the sacrifices of those who served in the military. Greenwood wrote it to honor the spirit of America and the pride that he felt in our country. And I thought it was the perfect song to play for our upcoming Memorial Day holiday. Okay, let's quickly go over the show format, and that is that we start with an opening topic, and then after that, I will open it up to questions for those people who are in the Zoom meeting. And if you do want to talk to me, you can electronically raise your hand. You can do that now because I do call on persons in the order that they did raise their hands. If you are watching this on YouTube, I would please ask that you hit that like button and subscribe to my channel because it really does help me. Okay, one more thing I wanted to say is that if you have any ideas about topics for me, please leave it in the YouTube comments section for this video. And maybe in a week or so, I'll be talking about the comment that you, or the seminar that you suggested. Okay, let's move on to the opening topic. And what is that? The opening topic is moving in and moving out, a comprehensive guide for California landlords. Yes, as a landlord, you have to deal with tenants, applicants moving in, and you also, of course, have to deal with tenants when they're moving out. So let's go over those so that you'll have the best knowledge and not get yourself into any legal troubles. So let's first talk about the move-in procedures. Before we even start thinking about tenants, we have to acquaint ourselves with the law, and one important law is dealing with fair housing law. There's both federal and California laws on that subject, and you have to understand that you're not allowed to discriminate on the basis of race, color, sex, including gender identification and sexual orientation. You can't discriminate based on marital status, national origin, ancestry, familiar status, disability, source of income, or arbitrary characteristics. And it's not just you who has to know these laws dealing with fair housing, it's your manager or your agent. Because if they make a mistake, you could be charged with discrimination, and that's the last thing you guys need. So be sure that not only you are aware of what these rules are and what you can and cannot discriminate against, but also that anybody who's your agent also knows these rules. Now, before you lease out your property, you need to know the specific legal requirements for that jurisdiction. So you have to check to see if there's any local requirements. And of course, if there are no local requirements, then you have to check to see if there's any statewide requirements. Some municipalities, for example, Los Angeles, require that you register your units as a rental. If you don't, then you can be held accountable and have a situation where you're fined or also potentially lose an eviction case. So know the rules for your jurisdiction. Now, you don't have to sit there and look up every city and every municipality and all the rules dealing with statewide rent control. You just have to know your local jurisdiction. And generally, if you go to the website for the municipality, you'll be able to determine whether units have to be registered, whether notices have to be posted on the property. So these are requirements that some municipalities and certainly some requirements dealing with statewide rent control that you have to be made aware of. So this is prior to even thinking about taking applicants to lease your property. Also, as you start to advertise your rental, you want to make sure that you're truthful in that advertisement, and also that it's not misleading. You want to be specific as to what you are offering. Are you offering a one-bedroom or a two-bedroom apartment? How many bathrooms? What are the issues dealing with parking? These should all be put into the advertisement that you're renting out your units, or that so that you can be truthful and not misleading with any applicant coming there. And of course, be mindful of all fair housing rules. Okay. Now, once you get past that, the next thing you need to do is you need to have a written screening criteria that you're going to hand to your tenant, which tells them, hey, these are the screening criteria that I require in order to gain access into my unit. I want to share the screen right now, and I want to put that up so that you guys can see that. And right now you can see this is on my website at evict123.com. That's evict123.com. And this would be a form that you can use. You can change it if you want, but it's pretty standard form that you're going to hand this to the applicant before anything else. And this tells you the requirements that, number one, I'm going to need to do this with regard to any application process. These are my income requirements, which must be at least 3 times the rent, for example, and that you're going to require verification of that income by pay stubs or otherwise. You're also going to tell them that you're going to check their credit history and that they need to have a rental history. You're also going to be telling them that you're going to do a background check. You're also going to tell them that we welcome Section 8. But these are all the requirements that you're going to ask your tenant to sign and give them a copy. So this way that they know exactly what's expected of them in order to gain access to your property. Now, if in fact they don't have this criteria, the concept of the law is that you wanted to make it so that they don't have to pay an application fee. Right now, under the new law, they don't have to pay a application fee unless you first give them that screening criteria. Basically, the concept of the law is that they don't have to pay for a criteria for a credit check if you weren't going to accept them anyway based on their credit application. So you must give them this screening criteria. Again, it's on my website before you take any kind of an application fee from them. Okay? Now, if you are going to do this, you want to make sure that you run one application at a time, because under the law, the new law, that if you take and run 2 credit applications at the same time, even if one application fails, you cannot charge them an application. You're going to have to fee. You're going to have to give them back that application fee for running that credit check. Okay. So this is really a good thing for you to do, because a lot of times tenants are going to, or applicants are going to sit there and charge you with discrimination based on the fact that they'll claim that, for example, that you didn't allow them in to the unit based on their ethnicity. But if you've given them your screening criteria and they failed because of that screening criteria, they're not going to have a really good argument that it was based on some sort of illegal discrimination. Okay, the next thing we want to show them is the application. You've already given them the screening criteria. Now it's time to give them the application. So I want to show you that right now. And this is a rental application that I have on my website, again, evict123.com. Someone asked me in a previous broadcast to update it to include where the tenant banks. So I did that. So this is brand new. And it goes through all the issues that you're going to ask for as to their name and social security, driver's license number. You want to understand who's going to be living in the unit with them. You want to have their rental history. You want to make sure that there's no gaps in their rental history, by the way. because if there's a gap, it probably means that they've been evicted before. Okay. You want to show their income from current employer, previous employer, etc. You want to show any other income sources. So this is a pretty uh, factual application, which basically ferrets out all the information you're going to need. Here are their financial institution, which we just added. But I also listed a bunch of questions that are so important that you want to put right on their application. Have you ever been evicted before? If the answer is yes, well, then you're not going to rent to them. Anybody who's been evicted before, you don't want to rent to them. Have you been convicted of a felony? If they answer yes, then you want to know when. Now, you just can't reject them on the basis that they have convicted a felony. It has to have some relation to your property at this time. So, for example, if they were convicted of drunk driving 20 years ago, that would not be sufficient for you to reject them now. Have you ever filed a bankruptcy? If you filed a bankruptcy in my position, I would never let you into my property. Do you currently smoke? Yes or no? You know how sensitive tenants can be to regard to smoke. You don't want any smoking on your property whatsoever. Do you have any pets? And if so, what type of pet? You might want to reject them because of that. But again, at least you want to know what kind of a pet. Maybe you don't want a pit bull. Here's an important one. Has a landlord ever requested that you move? If they've said yes, you want to know why they've said that, okay? And last but not least, have you been the subject of a lawsuit within the last 5 years? Obviously, you wouldn't want to accept an applicant if you knew that he sued his last 5 landlords. So these are important parts of the application that they have to fill out. And you want to make sure that when you go through this application that you do check their sources, okay? You want to make sure that you call their employer and don't rely upon the phone number that the tenant supplied. You do a Google check and make sure that they are the real number for that employer, because they might have given you a different number and their friends waiting to tell you how long he's been employed there when the truth is he hasn't. Okay, you want to run that credit check, okay? And as I mentioned before, you can only run credit check at a time if you're going to accept a credit application fee from this tenant. So one at a time. Otherwise, even if people fail, you'll have to give it back. But you don't want to just do a regular credit check. Like on my credit criteria, I said you needed to have a 700 credit score, but you just don't want to run it on just credit alone. You want to see if there's been any evictions. So you want to run an eviction credit report as well. These are all available from the apartment association, like the Apartment Owners Association. And you want to run that to see if they've ever been the subject of an eviction. Obviously, if they have, then you want to avoid them like the plague, okay? You also want to run a felony check. You also want to run a cell phone verification, that the cell phone number that they gave you, you want to run that check, which you can do through the apartment associations, and you want to see that that cell phone relates to the person whose name is on the application. This, there's so much identity fraud where people are going to give you phony names, phony social security numbers. But if you run that cell phone check, that cell phone that he gave you has to be adopted to the name that's on that application. So that's a really good way to determine whether there's any false identity. You also want to run a civil lawsuit check. You want to see if this person's been involved in a bunch of lawsuits having nothing to do with a landlord. If someone is getting sued all the time, that's probably a pretty good indication that you don't want this person in your property. Okay, the next step with regard to the move-in process is that you want to have a lease. Now, I have a lease on my website, which again, I'm going to share with you. And this lease is probably one of the best leases for landlords. It covers all the points that you need to have in your lease and really protects you. For example, this lease will provide that there is no smoking of any kind on the property. that there are no pets allowed. It talks specifically about parking rules, where you're supposed to park, how many cars, can it be an inoperable car, which of course not. It also states that repair requests must be in writing on this. If you don't have it in writing, then this way tenants can claim that they asked you to fix things. And then, of course, they really didn't. And then they try to bring habitability lawsuits against you, or they try to defend themselves in an eviction claiming that things were wrong. Well, you want to have that phrase in there that repair requests must be in writing. You also want to state that any misrepresentation on your application is an immediate ground to evict. So if you find out that that tenant really was evicted a couple of years ago, but on that application, they checked the part that states that I was never evicted, you've got a wonderful case to evict in that situation. And believe me, you need to have that in your rental agreement. So reason why I do put it in mine. You also want to have in your rental agreement that's no storage of personal property in the common area. You don't want personal property in the common area. It makes the place look like a slum. You also want to have it that when that tenant moves out, if he leaves any personal property behind, you don't want to have to go through the quote, personal property abandonment procedure. So I have a phrase in my contract that states that if you leave any personal property behind after you vacate, it's immediately considered abandoned and you have the right to immediately throw it away. You also want to have a situation where the tenant is required to have renter's insurance. This way, if any of his personal property is damaged, then he will not be able to come after you for that because the agreement states that your personal property insurance or renter's insurance will cover that. It will also cover the cost of relocating if your tenant has to temporarily be displaced from the property. Okay. Also, if your property is subject to statewide rent control, but is exempt, you want to make sure that you check that box, which I have in my rental agreement, that states that the property is exempt from statewide rent control. If you don't check that box, then your property is going to be subject to statewide rent control. Also under statewide rent control, if you want to have yourself or a child move in sometime in the future, you have to have a phrase in your contract that states that, hey, there might be a situation where I need to have a family member move in. And that needs to be stated in the contract. If it's not, then it's not a ground to evict under statewide rent control. Also under your rental agreement, you have to have a paragraph dealing with Megan's Law. That's people who are sex offenders. You want to have statements dealing with bed bugs, mold disclosures, and also that this is a flood zone. Okay? All right, let's stop sharing here. So that's the rental agreement, which again is on my website. So we have the screening criteria on my website. We've got a wonderful application on my website. And of course, we have the rental agreement. And again, all these forms, free. Just go to the website and go to the free form section. You also want to, of course, get a security deposit, the first month's rent and a security deposit. We all know that under the new rules, you can only get a security deposit equal to 1 month's rent, unless there's an exception that if you own no more than 2 separate properties containing a total of 4 units, then you are allowed to get a security deposit equal to 2 months' rent. So if I have a building that has 2 units and another building that has 2 units, I would be able to get a security deposit equal to 2 months' rent. But if I have a 4-unit building and another 4-unit building in a different location, then in that situation, I wouldn't be able to get a security deposit equal to 2 months' rent. However, as I've always stated, put one of those 4-unit buildings into an LLC. This way, there's different owners, and you would be able to get a security deposit equal to 2 months' rent. Okay, under the new law, you're going to need to take photographs of that unit prior to leasing it. prior to leasing it, which I think is a wonderful idea, even though it is a state law now, because this way you can show the world the condition of the premises that the tenant received the property in. So when you see cabinet doors ripped off and all the graffiti on the walls, you can say, hey, the windows weren't broken, the doors were on their hinges, and you can show the world based on these pictures. So I think that's a good law, and it's also, I think it's a good reason for a landlord to take pictures. Okay, with regard to the move-in procedures, you're going to get that first month's rent, you're going to get that security deposit, but you are not going to allow that tenant to occupy the unit unless you have received those funds and they have cleared your bank account. It's incredible, but people will give checks on a closed accounts. People will give a cashier's check, which you think would be a proper instrument, but we've seen now where there are counterfeit cashier's check. It's just insane. So make sure that no one gets into your unit until those funds have cleared your bank account. Okay, those were all the move-in procedures. Let's quickly turn to the move-out procedures. When a tenant is moving out and they've served you with a proper notice that they're vacating, or you've served them with a proper notice to vacate, you then have to give them the opportunity to do a pre-move-out inspection. Let's go to that form, which is also on my website. And that form is entitled Notice of Inspection Prior to Termination of the Tenancy. You have to, in writing, allow that tenant to do a walkthrough with you. You have to give it to them at least 15 days before their tenancy is going to be over, and give that tenant an opportunity to walk the property with you. And you're going to tell the tenant that you're going to be deducting for these items. You also have to give the tenant this in writing, what items you're going to be deducting for. Now, if the tenant moves out and you spot other items, you certainly can include that. So it's not an exhaustive list, because when tenants move out, further damage can happen. And also when they move furniture, you're going to see other issues. But at least the tenant has to be put in writing if he chooses to do this pre-inspection, which it's your obligation to give them this form at least 15 days prior to the time that the tenant is going to be vacating the unit. I might add, if you're doing an eviction on a tenant, you don't need to go through this procedure. But if it's a standard, I'm terminating the tenancy either by the landlord or the tenant, then in that situation, this form must be given to them. And then you have to, in writing, give them what items, if any, that you're going to be deducting from that security deposit. Okay, when the tenant does vacate the unit, you now have to, under California law, take pictures of the condition of the unit when the tenant vacates, and you have to take pictures of the unit once the tenancy is restored. Those pictures have to be included with the security deposit itemization that has to be sent to the tenant within 21 days of the tenant vacating the unit. Now, what can you deduct for from a security deposit? Well, you are allowed to deduct for any unpaid rent, cleaning, reasonable and actual cleaning charges, and those items that require where there was unusual wear and tear. So I get this question all the time. What is unusual wear and tear? Well, reasonable wear and tear refers to the normal deterioration of the property from ordinary use. Examples would be faded paint, worn carpeting, loose door handles, but does not include where there's been damage due to the tenant's negligence or abuse. And by the way, if you don't properly return the security deposit within 21 days, or you're deducting items that clearly should not have been deducted, a court can hold you in bad faith. And when your tenant sues you, not only can he get that amount of the security deposit that he was entitled to, but under a bad faith claim, he could get 2 times the security. Now, when you do send that security deposit itemization with any applicable refunds, you want to send it to the tenant's current address where he's moved to, or if you don't know that, you want to send it to the tenant's last known address, which would, of course, be your property. It's recommended that you send it by certified mail, but don't do it by certified mail return receipt. Just straight certified mail, and if it comes back to you, great. Then just hold on to it and don't open up that envelope unless you're sued in a court of law, and then let the judge do that. And that, everyone, is the topic at hand, which is moving in, moving out, a comprehensive guide for California landlords. Please review what I've just told you and check out my website, because it will tell you exactly what the procedures are for moving in and moving out. And right now, we're going to open it up to questions and answers for those people that are in the Zoom meeting. Once again, please electronically raise your hand. We all know the rules, and that is that this broadcast is for informational purposes only and is not a substitute for legal advice. Again, if you want to talk to me, please electronically raise your hand. This broadcast is for general questions only. If you do have a specific legal case with me, please save that by calling our office, and we'll be open next Tuesday because we are closed, of course, on Memorial Day. And if you are talking to me, please leave your camera on, because it does make the show much more enjoyable that we can all see each other. And you guys watching on YouTube, please hit that like button and open it up to subscribing to my channel. And now we're going to take our first caller. And our first caller is Julia Jordan. How are you, young lady?
Hi, Dennis. I'm good. How are you?
I am
Having a
fine,
wonderful day. And as always, thank you very much. So I got a couple of things this time. So the real quick ones. I looked for the trespassing form or document on the website. I couldn't see it. Is it a specific name?
Yeah, I'll tell you why you can't see it, because it's not in the free form section. It's in a
Oh,
section called legal issues. For everybody listening, if you have a vacant unit or house, and a lot of times these unscrupulous people will just jump in and claim that they have a lease with you. They'll make up a lease, and then the police won't, of course, evict them. But there's a form on my website in the legal issues section that you fill out that form, you hand it to the local police department for that area, and then post a no trespassing sign on the property. So if the police have received that, then you have the right to call for example, the LAPD, and they will arrest that person as a trespasser, because you did your due diligence by first filing that trespassing notification to a local police department.
okay. And then secondly, while I was on the website, I noticed something that you probably want to be aware of if you haven't heard it already. And under the special notice requirements for municipalities section,
Mhm.
you might want to look at the word requirements. I think we're missing an E on that.
Okay,
Okay.
I will view that.
Okay. And then real quick, so when we take these pictures, when we're moving, someone's moving in or moving out, are we required to give them a copy? Because I've been asked if they could have a copy of
Okay,
my pictures.
first of all, a couple of things. The law does require that you send them the before and after pictures with the security deposit itemization. Okay. And by the way, I didn't talk about it, but it is important to know that when you do run a credit report, you have an absolute obligation under the new rules to send that credit report within 7 days to that applicant. That's a change up in the rules. So if you do run a credit report, just immediately forward it to that applicant.
Okay. Thank you very much.
Okay, and thank you. We are going to be moving on to Jim Polina. How are you today, sir?
Doing great, Dennis. Enjoying my pool.
That's
All
a
right.
big one.
Yeah, I make use of it. So, a couple questions. One regarding the security deposit on a garage, as I keep the garage separate and I rent it for $0. So now I have a commercial lease for $0, and I tack on a security deposit on top of that. But when it comes time to make use of the security deposit, the garage security deposit, can I make use in the house? Or house, like lack of paying rent or damages?
The
There's a
answer,
crossover.
yeah, the answer is no. So you have a separate contract for the garage, and you're allowed to take a security deposit, anything that you want. There's no limitations because that's commercial lease. But you can't use that security deposit for the garage for any deficiencies for the house. You have two separate agreements.
So what do you recommend?
The most you can get, unless you have one of those exceptions, would be a 1 month security for your property.
Right. Okay. Got it. Second question, I'm going to repeat myself from last week on the idea of me asking potential applicants their source of income. And earlier on your talk this morning or this afternoon, you said you cannot be asking for the source of income. But then later on, you said, show us where your money's coming from. Give us some statements and cancel checks. And I can't reconcile those two concepts.
Okay, so they are reconcilable, I might add. With regard to, you certainly can ask the source of income, period. Where do you get your money from? You get it from the tooth fairy, it doesn't make a difference. You can certainly ask that, but you can't discriminate based on the source of income. So let's pretend you're saying, I'm a trust fund baby and I get $1,000 a month from my trust fund. You can't say, no, I don't want that source of income. I only want people who get $1,000, let's pretend, from their job. So you're discriminating based on the source of income. You certainly can ask what the source of income is. Do you understand the difference?
So obviously, I look at the amount of income. That's obvious. I can discriminate on the amount of income.
Well, you
But
can't.
whether
Sometimes a landlord, for example, will say, you know what? You get all your money based on alimony. I am not going to allow you, even if
okay,
you're making $3,000 a month. If you were making $3,000 a month on a job, that's one thing. But if you're going to get it from an alimony, then that's not proper. That would be
okay.
considered discrimination.
So I guess I am discriminating in my own head when I go, I don't want to hire or lease to self-employed individuals because it's hard to collect a judgment against them. That's not legal.
That certainly is not legal. But again, you have the right to verify, even if they're self-employed, that in fact they are making the money that they say they're making. You can certainly check that out. But I agree with you. If they're self-employed in terms of collection purposes, it's more difficult to collect because you can't garnish. But again, the money's got to go someplace. So unless he's keeping it in a shoebox, he's going to put it into a bank account, and we can usually find bank accounts as part of our debt collection. Anyway, thank you very much, Jim. We're moving on to Al, because we've got lots of callers. How are you?
Fine, how are you?
I'm good.
I remember a few months back you said you bought rental property in Las Vegas, and I was wondering how the laws, eviction laws, differ from here.
Okay, first of all, I didn't buy, quote, rental property per se. We're developing 67 acres of property in Las Vegas. It's a major commercial project that's going up, and that's ground has already been dug. However, the laws in terms of evictions in Las Vegas and Nevada are so much easier for landlords. It's really a very streamlined procedure, and there's not many defenses that the tenant can raise.
Oh, really? Okay. Do you do evictions in Las Vegas or recommend somebody?
I actually do. The person's name is Ann Colber, Kolber. She is in Las Vegas. She used to work for me, and then she started her practice in Las Vegas. So check it out, Ann Colber, Kolber. Check out Attorney Las Vegas. You'll find her.
All right, thank you very much.
All right. I gave my old associate a plug right there. Maribel, how are you?
Hi, Dennis. First of all, I'd like to say it was a pleasure meeting you at the AOA convention. My question is, as I mentioned before, I just closed on a fourplex in Gardena on April 16. Well, a few days later, I found out that there was sewer water leak that was not disclosed to me prior to close of escrow. I know this is not your area of specialty, and I'm looking for a real estate attorney who can help me through this. If you know somebody, if you can recommend.
Well, what you're referring to is that the seller of the property didn't disclose that there was a major plumbing issue.
Correct.
So if you do call me at the office, I can give you a referral to somebody. What is the cost to have that corrected?
Yeah, well, the cost first, how it happened was the water company had some project outside of the complex, and sewer line, I guess, was hit, and it seeped through two of my units. So what was your question? I'm sorry.
The question, what is the cost to make that repair that wasn't disclosed by the previous owner?
Yeah, so as soon as I found out that there was water leak, which was disclosed to me by the tenant, I sent a water mitigation company, Surf Pro, to start their assessment and stuff.
I know, Maribel, but let's get to the answer. What do you think the job will cost to make the repairs?
About more than $50,000.
Okay, yeah. So obviously I was seeing whether it would be like a small claims court matter, which is up to now 12,500. Yeah. Give me a call at the office and I can certainly give you a referral. And with that, we're moving on to, because we've got lots of callers. Gloria G, how are you?
Hi, thank you. I'm in the city of Rosemead Incorporated. I have a single family home and we're getting ready to rent it out. And we were wondering if we might run into any problems if we plan to use, we have an unpermitted granny house at the back of the property that we'd like to use a few times a year when we're in town. Do you think that would be any problems?
I don't see that as a problem. Just make sure in the contract you state that there is an unpermitted unit in the back and that it is not being leased and that we're retaining that. However, I probably would want to take out the kitchen sink, so that it's more of just a shed, because you can get into some issues that the fact that now that single family home would be considered under statewide rent control potentially, because you have two units on one lot, even though one of those units is not legal. So if you can take out the kitchen and make it more like just an enclosure, then I think you're fine, and just exclude that from the rental agreement.
Is the bathroom okay?
Probably the bathroom would be okay. Just make sure that there's no kitchen.
Okay, thank you.
All right. Cassandra, how are you?
Okay, good afternoon. Can you hear me okay?
Yes.
Great. Okay, two questions. I'll try to make them quick. A section of my lease agreement discusses late charges and return checks, and it says that the owner does not waive the right to insist on payment of rent in full on the day it's due. And so this particular tenant they're on a subsidy program. It's not Section 8. It's like Brilliant Corners or Hopix, if you've ever heard of those two. So
I have.
Okay. So the tenant, they pay on their portion on time, but the program is very late, like 20, 30, or even more days late. I'm wondering, how can I notify them that the landlord is now going to insist that only rent in full on the day that it's due will be accepted? And how many days notice do I need to give them?
That's why I'm generally not a fan of these organizations. So I haven't heard that they've been paying rent late. Normally, they're the ones who are paying on time. So before I would start with any kind of quote legal demands, I would contact that program and find out why your check's going out late. I think there's probably some sort of a snafu on their side, because they generally pay their rents perfectly on time. Also, you might want to just give them, if you haven't done so already, your banking information so that the money will flow right into your bank account.
Yeah, I've done that. And in addition, I would like to try to find a way to remove the tenant. So I'm kind of thinking, okay, this might be a good way to.
Yeah, I mean, the tenant is ultimately responsible. And if the rent isn't paid timely, then technically the late charge would kick in, assuming you have a legal late charge provision in your rental agreement. So I would first send a warning letter to the association that's paying the rent. I'd also send a warning letter to the tenant that, hey, we've got to get our rent on time. Otherwise, we're going to be considered terminating the tenancy.
I mean, I have done that, so I guess I'm wondering, is there like an official notice or just kind of like you're saying?
Well, at this point in time, I would then proceed forward with a notice to a performer quit to pay the late charge. And if they don't pay it, then we have the right to evict. However, I can just see, notwithstanding the fact that you have the legal right to do so, I could just see a judge just hemming and hawing about going forward and evicting this tenant when it's the organization that was paying late. But then again, you're a landlord. Why shouldn't you be able to get your rent on time? You've got to pay your mortgage on time. So
And
I
unlike,
might reach out one more time and saying, this is what we're going to be doing if I get rent late.
okay, I'll do that. And then also these organizations, there's no agreement between the organization and the owner, right? Like Section 8. These are
No,
like
the agreement is between you and your tenant, and yet the tenant has somebody helping him pay the rent.
Okay, gotcha. Okay, my second question, I'll try to move along regarding the late fees like you were talking about. So my rental agreement says late fee is 6% of the delinquent rent, and unless prohibited by law or ordinance, such late fees are deemed additional rent. Do you know of any local laws that specifically allow this or disallow this?
I don't, but if that's the entire paragraph, I don't think that's legal. You have to have special language that talks about that these charges are difficult to compute, and that's why we're instituting this. You might want to take a look at my rental agreement and go to the late charge provision. It's got to have language similar to that. Otherwise, it's not a proper late charge. We are moving on to Richard Malley. How are you, sir? Richard Malley. Okay, Richard. Let's move on to C. McLean. How are you?
Hi, Dennis. This is Carrie. I have a quick question regarding the allowable rent for the city of Los Angeles.
Well, before we go on, I want to compliment your hat. Go ahead.
Go Lakers. Thank you. Yeah, so we have a condo in the city of Los Angeles in the Palisades, and we have our rental, our tenants are moving out. So can we raise the rent up just 8.9%, or is it 10%?
This is a condominium?
Yes, in the Palisades Highlands.
And I've said this many times, notwithstanding the governor's emergency order, which is set to expire as of July 6th. As a condo, you have the right, once the unit is vacant, to raise the rent to whatever you like. There is no limitation. There is no price gouging. These are all ridiculous theories. So feel free to raise the rent to whatever you like.
Okay, and then will the regulations change on July 6th or after
Well,
that?
then there would be no emergency order whatsoever, so there is no issue dealing with rent gouging.
Okay. All right. Thank you, Dennis.
And thank you. Moving on to Ryan Fitzgerald. How are you?
I'm well. How are you?
I'm good, thanks.
Quick couple of questions, actually three quick questions. Can you do videos instead of pictures? Because what I do with my rentals is I shoot a video, I send them the video link, and I say, please verify that you're in comply or you're in agreement with the condition of the place.
The answer is the code specifically says to take pictures, and videos are not pictures. So you could take your videos too, but I would certainly snap a few shots.
Okay. And if a place is furnished, like a high-end furnished rental, are you in any way able to get that 3 months security deposit? Is there any way to get more of a deposit if you have a high-end rental?
And the answer is no. The law specifically doesn't have any issues whether it's unfurnished or furnished.
Okay. And then as far as appliances in your lease, does your lease address that, like, because I have appliances, but I don't want to be responsible for them. They're just kind of given as gratis. And so if something happens, then the tenant's responsible to fix them.
Yeah, I don't have a provision like that in my lease. You'd have to do as an addendum to the lease,
Okay.
which
The
states
CAR lease that talks about that.
Yeah, absolutely. All
Okay.
right, well, thank you very much. Cheryl G. Tell, how are you?
Great, Dennis. Long time no talk to. But I do want to tell you, I really am grateful. You had mentioned a while back about having tenants go month to month or start them on a month to month. I was really hesitant to do that, but I have one of my units have been rented out. They're started as month to month. They've been there about 8 months. They're a wonderful couple, and it's really worked out very well. So thank you for that. My question is, in one of my other units, there is no washer dryer hookup, and the tenant asked me if there's a way we could, or if we could go ahead and put in a washer dryer hookup. Now, this is something we thought of before, but probably we're not going to do anything right away. When they rented the place, there's definitely no washer and dryer hookup. My question to you is, if we were to do this, can I raise the rent as it is a new amenity, or I can't base it on that? I can just do a regular increase in rent.
What city, please?
Downey, sorry about that. Downey, and it's 2 houses on 1 lot.
Okay, so you're under statewide rent control. The most you can get currently is 8.9%. You can't charge anything extra than that.
Okay, all right. So I wouldn't base it on, okay, now you have washer dryer hookup, I'm going to increase your rent. I would base it on just the regular increase in rent.
Yeah, I guess what you could do would be to charge a separate washer and dryer leasing fee. I don't see a problem with that because you're going to put in the washer and dryer. You're going to do the hookup.
No. I'm not going to put in the washer and dryer. Only going to adjust the plumbing and gas so that they'll be able to buy their own washer and dryer.
Yeah, then the answer is no.
Okay, all right. But I can just do a regular increase in rent.
Always, if you haven't increased the rent in the last 1 year period, you can raise it 8.9%. We are moving on to Arthur Amir. How are you?
Hello, I'm good, thank you. I purchased a duplex in Los Angeles, RSO, specifically to live in both units. It's a 2-bedroom each, but me and my wife and 3 small kids, we want to live in both units. But also, my mother-in-law would come in, but I don't want to put her name on the eviction because I'm not sure if we're going to, make it for 2 years with her, or if somebody else would come in one of the rooms. Can we get both units for just me and my wife name?
Okay, this is in Los Angeles under the rent stabilization ordinance?
Yes.
Okay, the people who are living in those 2 duplexes, is anyone over 62?
No.
Okay, so you certainly have the right to take both units. Obviously, you're going to be taking title in your name and in your wife's name. And your wife can claim that she wants to move into the left unit and you're going to move into the right unit. So I don't see any problem with that whatsoever. There is an exception under the LA rent control ordinance that if a person has been in the unit for more than 10 years and is over 62, then you're not allowed to ask them to move because you want a family member or yourself to move in.
Okay.
All right, thank you very much. I'll go back to Richard Malley, see if you're not asleep at the wheel. Are you there, Richard?
Yes, I am. Hi, Dennis. Sorry
Hello.
about that. I had to take a call. All right. Hey, this goes in reference to your opening statement, the lease agreements, and in a scenario where your conditions or terms of tenancy, let's say, are not on my lease agreement. I was looking on your forms section and I didn't see anything, a 30-day notice, change of terms of tenancy. Can I take a paragraph of one of your terms of tenancy and serve a tenant a 30-day notice, change of terms of tenancy, add that into
But for what issue?
Well, nothing that comes to mind, but let's say it's nothing, well, it's nothing to do with rents or deposits or amount of occupants or pets, stuff like that. It's more of your boilerplate terms that are on a lease agreement.
Well, let's go back to share the screen, okay? And let's talk about that. So right now, as you can see here, this is my free form section. And I do have a lot of those types of forms there. This is one here is the rent increase notice. But this
Right.
one here, for example, is if your rental agreement doesn't require your tenant to carry renter's insurance, this is a 30-day change of terms to do so. Okay. We also have ones in here that say repair request must be in writing.
Got
This is one here that talks about that if you don't have a limitation on attorney's fees, in case you get involved in a lawsuit, you want to make sure that you're
Got
not
it.
going to get hit with a bunch of attorney's fees. So that's a 30-day change of terms of tenancy. This one here is smoking. You can serve that notice on them. So I have a lot of ones in here that are change of terms of tenancy for most of the issues.
Got it. Understood. Okay. So there, you don't, there's not a blank form 30-day notice of change of terms of tenancy.
No, but you can
would
just
think-
use the language in that and just should white it out and put whatever you do want to change the terms
Right,
of.
because I remember I used to have, I used to use those forms pretty often in the past. One last question on a, if I no longer own a building and my past tenant had a back rent owed, and what's the jurisdiction I'd have to sue that tenant for the back rent owed?
Okay, well, first
Or
of all,
what type of
even though
court
you
remedy?
sold the building, if the guy owed you rent from 2024, for example, you're still entitled to that. The new owner certainly isn't. And you have the right to sue that tenant. Presumably, you can do it in small claims court. Usually, there's a 4-year statute of limitations on a written agreement.
Right, and what's the limits on the small claims court? Is it
It's
10,000?
$12,500.
12,500. Thank you, Dennis.
All right, thank you, Richard. Zena, how are you today?
I'm well. How are you, Dennis?
Going through these calls, it's just like being at the office.
All right. You're doing a fabulous job like always. All right. I have two questions. I just need them clarified. So renting, when you're getting a deposit, regardless if you have one property, one structure, unsubsidized, I guess, property, you only are allowed to charge 1 month's rent. Is that correct?
Are we
Regardless.
talking about a security deposit?
Sorry, I meant to say security deposit, correct?
Okay, so if you have just a single family residence, then remember the exception is if you own no more than 2 properties with a total of 4 units. Well, this obviously is less than 4 units, so you can certainly get a 2-month security when you lease that property out.
Woohoo! Okay, thank you. The next question is, I also need to post outside of the property that it is not under rent control.
What city is this property?
Oh, Pomona, city of.
Okay. If it's Pomona and the city of Pomona, there's nothing to post. You are under, if this is a single family residence, you want to make sure that when you lease the property out, you check that box that says this property is exempt from statewide rent control, but there's no other notices that need to be posted for the city of Pomona.
Okay. So, all right, I don't need to put it on the property. Thank you so much. And I got to say, woohoo again.
Thank you. Sonia, we're going to see if we can get through these calls. How are you?
Hi, Dennis. Thank you. So yes, real quick, and regarding the rental, the criteria for renting and the application. So if we have we are not charging for the rent application, and we give the tenants a rental criteria. Once we get maybe 2 or 3, and before doing any screening of the reports, once we start going through it to verify where they live, references and that, can we start one and start another one while we wait? Is that okay? Because we're not charging any fees, because sometimes it takes a while to get verification of employment. It takes a while to get someone back to us for a personal reference.
Well, according to Fair Housing, it's the first qualified applicant. Okay. So, and again, if you're not charging a fee, then you're fine. You can take more than one application and run there and run as many credit checks as you want. as long as you're not charging the tenant for that. Otherwise, if you're charging the tenant a credit application fee, then you can only do one. And if that person qualifies, he gets the unit. If he doesn't qualify, then you get to keep his application fee, and then you move on to applicant number 2.
Okay, thank you.
All right, thank you. We are moving on to, let's move on to LKJLC. Are you there?
Yes, hi, Dennis. I've got a question for you. I hope you have a good answer for me. I have got an eviction that I just got the sheriff to post the 5-day notice. And then I got a letter that says the lockout date is in July 23rd. I'm wondering, is that sounds really odd that it's 2 months out. Is there any way to accelerate that?
Well, first of all, it's insane. The sheriff serves under the law. The sheriff has to serve a 5-day, you better get out notice to vacate the premises. Normally, when they serve that notice, the sheriff would be there sometime the following week. Now they're taking 2-3 months. This is a plot by the County of Los Angeles, their supervisors, to slow walk evictions. They claim that they're understaffed. It's a bunch of hogwash. So have I seen that in my practice? Absolutely, where they'll post a 5-day notice, and they did that at the end of April, and then you get a lockout date for July. This is just theft of your money at the hands of the County Board of Supervisors.
So there's nothing that can be done to have them come earlier. There's absolutely nothing that can be done.
No, unless you have a friend at the sheriff's office. That's about it.
Oh, I was hoping you'd have a better answer, but thank you, Dennis.
I don't. I wish I did. Let's take a look. I wanted to go back to Xena. I realized that Pomona does have a rent control statute because I looked it up. I'm not sure if they require anything to be posted on the property. My guess is no, but I don't really know for sure. You might want to call the office or call the city of Pomona, but they do have their own rent control. And now we're going to move on to Gid Martin. How are you?
Oh, I'm doing fine, Dennis. Thanks for taking my call. There's a rumor that Giannis is coming to the Lakers, and we'll talk about that another time. Listen, I did want to mention that the 5-day lockout, they don't tell the tenant. My tenant moved out based on the 5-day lockout. They only tell the landlord that it's backed up. So sometimes that helps.
Yeah, no, that does help. They get scared because the tenant's thinking that they're going to get locked out on the 6th day. But
Exactly.
if the tenant does any checking, he'll know they're not going to be there for a month. But we have had many tenants who have moved after the 5th day.
Yeah. Okay. So your form for vetting that you went over is on your website?
Yes.
And is there a way, I've got a condo in Los Angeles that I'm getting ready to put back on the market. I just want to know if there's a way to avoid relocation fees. I think the minimum is $18,000 if you want your tenant to relocate. Is there a way to avoid that at all?
So what I'm guessing you're saying is that you're leasing the property to somebody, and then maybe sometime down the line, you now want this tenant to move and you want to see if there's any way to avoid relocation.
That's excellent. Yes.
Okay, well, first of all, if this is in the city of Los Angeles, you need good cause to evict. So if you don't have good cause, you don't even get to the part of relocation, okay? But let's pretend you wanted to, in a couple of years, you know what, I want to occupy this property myself. Well, then you could ask this tenant to move unless the tenant's been there longer than 10 years and is over 62. But you are going to have to pay relocation, the amount as requested by the city, and there's no way for that to be waived.
Got you. Okay, I appreciate you, Dennis. Thank you.
All right, thank you, sir. We are moving on to Juan Calderon. How are you, sir?
Can you hear me? Can you hear me?
I can.
All right, yeah. I just want to ask a quick question about the deposit. I live in the city of Whittier, the actual city of Whittier, and I built an ADU in the back. It's 2 years old. Would I be able to, in the future, is it just 1 month of a direct deposit, or can I ask for a 2?
How many residential properties do you own in the state of California?
I only own one, and my front house and the ADUs in the back, so it's kind of
So you're fine. You can get a 2-month security because you're the exception.
awesome. That's it. Thank you.
And thank you, sir. Sam, Shabbat. And it is Shabbat, I think.
Yeah, Shabbat Shalom. Yeah. Thanks, Dennis. Question. Suppose a homeowner is nice enough to let somebody outside who's wanting to use their restroom come in and use their restroom. Somebody from just asking. They refuse to leave the house. So the homeowner calls the police. The police say it's a civil matter. At what point can the homeowner use force? And I'll let your imagination run wild as to what you think force means to get this squatter out. And there are professional squatters, guerrilla squatters that do exactly this behavior. And I'm sure
Okay, well, first of all, I want to see the guy who's letting some guy come in off the street to say, hey, can I use your restroom? That's number one. I can't imagine anybody's going to do that. But if they did do that, you could still throw the person out and the police would assist you because the person has to be there at least 30 days to gain any rights.
But not City of Long Beach. They say it's a civil matter. You have to go through an eviction.
And so you're telling me that somebody just moved in? I would use self-help in that situation.
Self-help, okay.
The guy just walked in 2 minutes ago.
Okay.
And now he's claiming that he has a possessory interest. That's not under the law.
Okay. Thank you.
And thank you. Well, ladies and gentlemen, we have come to the end of the hour. I do appreciate everybody who has participated in this forum here. And again, if you are watching this on YouTube, I would ask that you hit that like button and subscribe to my channel because it does help. You know, we have a toll-free number at the office, which is 1-800-77-EVICT. If you've got questions, you can call up whether you're a client or not, and we're happy to answer your questions at the office. We can give you some practical legal advice if you have a quick question. I want to wish everybody a happy Memorial Day, and with that, I want to say goodbye. Take care.